Thank you, Mr. Chairman. I would also like to thank the witnesses for being here today. And the question was asked earlier if any of you are scientists, but I would like to ask the question, are you all constitutional lawyers? And the subject we're addressing today is on a matter of free speech, not necessarily the issue of what the free speech is over, so I appreciate you being here with your expertise. Professor Foley, I would like to ask you, is the First Amendment a blanket shield that can be used to prevent compliance with congressional subpoenas?
No, it's never been viewed that way by the court. In fact, in the criminal contempt cases where it has been raised, what the court has said needs to happen is a balancing. It balances, on the one hand, the weight of the interest of Congress in obtaining the information, which is usually given what the court calls great weight, and they balance that against the interest of the private individual from whom the information is being sought. And unless the court sees some prima facie evidence that the information is being sought by Congress for the purpose of harassment or intimidation, usually that balance comes out in favor of Congress.
Okay, so the U.S. District Court for the District of Columbia recently ruled regarding a First Amendment privilege claim in response to a congressional subpoena. Are you familiar with this ruling?
Which ruling is it? Tobin?
Yes.
Yeah.
So would you summarize the district court's ruling in this case?
Yeah, the Tobin case is one of those balancing cases, and I believe that, let me see if I can find it. I think I've got it here in front of me. No, I don't. I believe that the court basically did the same balancing that I'm talking about, and...
Yeah. Yeah, I was actually referring to the back page.
Which one?
On the CEO call Farrar on the Chief Judge Justice Roberts has currently stayed the Senate committee subpoena, the back page. So the legal opinion.
I'm not sure which document you're referring to. Chief Justice Roberts stayed in opinion.
Right.
Yeah. So, Professor Turley, are you familiar with this?
Yes. I mean, the district court gave a very strong endorsement of the power of Congress to seek the information. This, I believe, was Judge Collier issued the opinion, a very respected judge. Chief Justice Roberts, though, did issue a stay and has ordered for further argument to occur.
Okay, so given the district court's ruling, do you agree that groups asserting First Amendment privileges in instances where a congressional subpoena has been served cannot use as a blanket shield to prevent the production of any information to Congress?
Generally, no. Generally, that's an issue that's worked out with logs and indexes and negotiations. What you'll notice, by the way, about many of these cases that we're citing is that in many of the cases, these people did, in fact, testify. But then they refused to answer some questions, and those issues went to the court. In a couple of occasions, the court has said, look, that had nothing to do with what your authorization was, the subject matter. But actually, in these cases, what's often ignored is that they actually did respond to Congress. They did testify. They drew a line, as with the NAACP cases, of answering questions with regard to membership. The idea that you can just say, well, look, I have a First Amendment protection here. I'm not going to respond to any information that the committee is seeking, including information that may, in fact, be public in some regards, I don't think would be accepted by any court.
Okay, so according to the district court, must groups asserting a First Amendment claim still define the universe of responsive documents and search for those documents, even if they maintain that those documents are privileged?
Right. What you do is you then work that out through the index and the log. You raise your basis for the privilege. If it's a non-constitutional privilege, the committee then has to decide whether it will respect that. In my experience, being around this place for a while, most committees, in fact, do reach compromises. A lot of times it's not worth to have a fight over much of this stuff, and you can get summaries or redactions that avoid those issues.
So must groups produce documents responsive to a congressional subpoena that are not privileged?
Yes, and the other thing to remember is that whatever Congress does, particularly with these groups, are going to have usually an element of free speech associational interests. That's very, very common. Every committee has to deal with that. What is important is that principle doesn't require you to be civil. It does require you to be consistent. And the committees of Congress have, in fact, subpoenaed public interest organizations like the tobacco groups to produce information, and they've worked out these disputes in the past.
And, Mr. Chairman, I would like to submit for the record an article here, says the Supreme Court refuses to block back page subpoenas in sex trafficking investigation, referring to this back page case.
Okay, without objection, that'll be in the record.
I yield back.
Okay, thank you, Mr. West.